Hi everyone. So I think it's 3 o'clock. We will start now. Thank you so much for attending our talk today. My name is Lee Zai-Lii. I'm the senior associate in RDS, and I have my colleague Diane here with me. She's actually directly opposite me. And yeah, we are the associates in the Capital Markets and M&A department of RDS under Mr. Ong Eugene. And today we'll be talking to you about IPOs and also the due diligence exercise that we conduct in relation to these IPO exercises. So then can we say hi to everyone?
Yeah, hi everyone.
Okay, so to start, in relation to initial public offerings, which in short is usually called IPO. It's basically the listing of a company on a relevant stock exchange. So in our case, it's mostly the Malaysian stock exchange. So there are a number of stock exchanges in Malaysia. Essentially, there are three. That's the lead market, ACE market, and also the main market. So to us, in a corporate field, in a corporate department, I think what we think of it is a muffin or a cupcake, and basically the whole of the cupcake is corporate, where you would have M&A exercises, you will have real estate exercises, and also in our case the capital markets, which is actually divided into two separate sections, which is debt capital market and also equity capital markets. Today we will be talking about equity capital markets, and to us, equity capital markets is the cream on top of the cake. So don't quote us on this. This is basically just us essentially letting you know our views as to what capital markets is to us. And the cherry on top of the cake here essentially is IPOs to us. So it is to us the most elite type of transactions that we can get in relation to a corporate exercise. Yeah, so we have extracted this out of Bursa Malaysia's web page. This is basically the listing process of the main market and ACE market process. So right here, we have 4 stages: the pre-submission stage, the regulatory approval stage, the post-approval stage, and also the listing stage. So essentially, if you add all these up, I think it would be around 44 weeks. That is 10 months, and essentially it is more than your pupillage. But this is provided if you know the whole transaction runs smoothly and there's no hiccup in between. And I think for most IPO exercises, I'm sure Diane would agree with me that there are a lot of hiccups and there are a lot of matters to resolve prior to you actually being able to move on to the second stage, which is the regulatory approval stage. So here we have, just to briefly go through with you what would happen. On the pre-submission stage, which is the primary stage, you as the company would be appointing advisors. So in this case, the most important advisors would be the principal advisor. Usually that would mean it's an investment bank or a securities firm. This securities firm may be, M&A, Mercury, or even what's the other one, Diane? TA Securities. Okay, and the next one would be the legal advisors. This is where we come in, we as lawyers, where we provide legal advice to the clients. And also there will be the reporting accountant. Usually they will be the auditors of the company already, and the corporate secretary, which runs all the corporate secretarial documents for the company. There will be the IMR. The IMR is essentially the independent market researcher. They will be the one that provide the company with a draft of an industrial overview. So industry overview. So basically, they would have a 10-pager of what the industry is, what the industry of the company is, and basically how the whole process of the company itself. And essentially there will be the advisors will be coming together to provide the company with the structure of an IPO, and due diligence and internal control review will be conducted. And after all this is done, we will be preparing documents for submission, and it will then go to the regulators. So during the second stage, this is where the pre-application submission pack come along. So this is something where it is kind of new. It is a document to be submitted to the regulators. So in the main market context, it will be submitted to the SC, and in the ACE market context, it would be submitted to Bursa. So in this stage, you'll be coming up with a really long form of information about the company to brief ST or Bursa about what the company, what the business of the company is, and basically whether or not they are in compliance with the law, and whether or not there's anything to highlight to the regulators. So in this stage as well, after the pre-application submission pack, you would then proceed, if everything is clear with the SC, you would then proceed to submit to SC the prospectus, which is a really thick document about the business of the company and everything else, where the financial information and everything will be included inside, and also the application for listing will be submitted to the regulators as well. And this is where you address the queries from the regulators, and also the regulators will visit the sites of the company. Let's just say the company has a few factories, or the company's headquarters, or places where the company conduct their business. And then subsequently, post-approval would happen. So this is where an approval is given by the regulators. And this is where the company would appoint an IR company, and there will be an underwriting agreement to be signed with the relevant investment bankers, and also registration and lodgement of the prospectus would happen. So this is where some of the parties might happen, and this is where we get to attend some of it as well. And in relation to the most fun part of an IPO exercise, that we would say is the listing part, and this is where all parties are at. So the prospectus launch would usually be, in a nice hotel or anywhere nice, like I don't know, some convention center or something like that. And a roadshow will be done by the investment bankers. That's where they go and advertise the business of the company, and to sell to investors, to tell the investors why do you want to subscribe to the shares of the company. And then on a specific day, they will be listed in Bursa Malaysia, or in Bursa Malaysia. So this whole process, we say here it's 44 weeks, but in most cases it will be more than that. Yep. Okay, so we move on to the next slides on the roles of a legal advisor in an IPO exercise. So essentially what we'll be talking today is more on due diligence, but we do more things than just conducting due diligence. Other than conducting interviews, site visits, we also draft the agreements that come along with the whole exercise. Basically, in an IPO exercise, you would do some restructuring, where the company have to come together in a group, and also we draft the prospectus. So this is the tick document that I was telling you guys about in relation to the business of the company and etc. And also we, as and when, do provide legal opinion to the company or the advisors that requires them. Like it can be an opinion of anything that is made. It can be an opinion of anything essentially. And we conduct and attend all meetings, and we also write the minutes, because we are essentially the secretary for the DDWG, that is the due diligence working group that is formed at the stage of establishing the IPO. And also we do engage foreign counsels as well. So this is when there are subsidiaries of the company that are in another country where they are conducting their operations and business. We do need foreign counsels to conduct the due diligence in that country as well, in order for them to sort of, verify with us, and also help us find out whether or not the company is in compliance with the laws in that country. Yep.
Okay, I think I'm told that I should use my own mic, so I'll just, so Lily, you.
Yeah, I'll mute here.
Okay, yeah, so
No.
yeah. So what is due diligence? So diligence is basically a process where a lot of questions are asked. When a company wants to go for IPO, all the advisors come together that forms this due diligence working group. Will be asking different sets of questions to this company to basically we are working towards one same goal, that is to ensure that all our submission documents to the regulators, be it the Securities Commission or Bursa, that all our information are not false and they are not misleading, and also that they are to ensure that there are no material omission in whatever we submit to the regulators, because this is an obligation not just on the company but also on the whole due diligence working group. So when we say reasonable inquiries, there's nothing prescriptive about it. So it is really up to the due diligence working group to come up with the extent of your due diligence. How much do you think you need to dig on this company to ensure that everything that we submit is accurate? So that is in respect of IPO specifically. And when we say reasonable inquiries, we are basically, we are trying to ask the company basic questions and more follow-up questions as and when necessary. For instance, who owns the company? Who are the substantial shareholders of the company? Who is the director of the company? Who is the one driving the business of the company? What is the company doing? What's their business? Where is the business operations of the company based? And where are their properties located? Why is the company going for IPO in the first place? And why is the company doing certain things that they are doing? For example, if we go do conduct due diligence on this company, and we realize that in the past 1 month, the company has been actively selling all of its properties. So then it needs to raise a few questions, or why is the company doing that? And how, when it comes to how, when we look at all their licenses and approvals, how is the company, complying with all the relevant conditions of their licenses? How is the company complying with, most importantly, complying with all the relevant laws and regulations? So this is, in terms of the laws and regulation, the compliance, that is more relevant to what we legal advisors do in an IPO due diligence, because I think ultimately at the end of the day, we need to confirm and we need to tell the regulators that, yes, this company is in compliance with all the relevant laws and regulations that is applicable to them. So that is the whole idea of due diligence. There's no one-size-fits-all approach to, how much you want to ask, because you just need to satisfy yourself and also the whole working group that, yes, the company has given us all we need to submit this IPO application to the regulator. Okay, so when we start off, when we commence this IPO exercise, one of the main components or key tools for it would be a data room. So data room can be divided into two types. Last time, I think before the MCO hit, there used to be a physical data room, and it is what it is. Basically, the company, they allocate a space in their company for any advisors to go and to do physical due diligence, meaning they will provide us the physical documents and we will cite and review the documents on the spot. And this would come in handy when, especially when the documents are super bulky. So we've had a file where we did due diligence on this construction company, and you know how the construction contracts of these companies are very thick. Every project has thousands of pages, and it would be extremely voluminous for the company to scan each of them and to upload it to a virtual data room. So in circumstances like that, we would have to then go to the physical data room or the company's physical site to review the documents. And this would also come in handy when the documents that we cite are of a sensitive nature, or if there are any confidentiality reasons behind the company. Because when you upload documents virtually, there are a higher risk of security. There may be more security issues or security concerns by the company. So sometimes they prefer to just let us go and cite it ourselves. So in light of this whole COVID-19 situation recently, I think the more popular option would be for us to use a virtual data room, and that it can be on any sort of cloud, any sort of private servers, but it's basically where the company will upload all their documents. We will send them a list of documents that we want, and they would then upload it according to the folders onto this online virtual room. So this is really convenient for both us and the company because number one, it saves time and it saves costs. So we don't have to travel down to the company so many times to just review different types of documents when everything is on this virtual data room. So I think this is the more popular choice used by a lot of advisors nowadays, also because of the whole social distancing norm recently. So, but however, obviously for confidential documents, we will still have to go to the company site to cite the documents. So this is one of the main tools for due diligence. Then, which one? Yeah, done already. Yeah, so in terms of data room, the next tool for due diligence is a due diligence checklist. So this is sort of an information requisition checklist where we will, right at the beginning of our IPO due diligence, we will come up with a whole laundry list of documents that we want from the company. And when we say it's a long list, it is a very long list. A lot of our clients, they actually get a shock when they first see our list, because I would say that IPO due diligence is one of the most extensive due diligence you can conduct in any sort of corporate exercises, because what we are looking at is everything in a company, because at the end of the day, we are presenting the company to their prospective investors when they get listed. So that is why we are basically turning the company inside out, and we're looking at every single aspect. So in this slide, we have listed down most of the things that we usually look at, but not all. It really depends. The scope really depends on what the company is doing, the nature of their business and all. There may be more, but the usual ones we look at are, for example, their material contracts. So we'll look at their contracts, in particular, those that are not within their ordinary course of business. So remember just now when I say we need to ask, why is the company doing certain things? This is where we can see what the company has been getting themselves into in maybe in the past 3 financial years. We want to know what kind of arrangement they've gotten themselves into. Are they doing something out of the ordinary? And if yes, what's the justification? What is the reason for them doing all this? So we have to review all these contracts and to see, because if these are contracts that they are, exceptionally dependent on, so if they enter into this agreement with this major supplier that they are extremely dependent on, then it is something that we may need to disclose in the prospectus. And following from that, we would then have to look for confidentiality clauses, because a prospectus will become a public document. And if you do have confidentiality clauses in your contracts, you would then need to go back to your counterparty and ask them for consent, whether or not I can disclose this in my prospectus later on. So that's something that we'll look at. The next thing would be the licenses and approvals of a company. So basically, every company, when they conduct their day-to-day business operations, we need to know whether they have the necessary license. For example, if I'm a manufacturing company, I manufacture certain products, then I will need definitely I will need a manufacturing license for me to do whatever I'm doing. If not, I will be in breach of the law. Or other licenses, it can be business premise licenses, as something as simple as a business premise license. If I have 5 offices throughout Malaysia, all 5 offices should have this business premise license. So it can also come down to something as simple as, when I import certain products, I need to have certain certificate of conformity to show that this product is a certified product by the relevant authorities. So depending on what the company does daily, we will need to ensure that they do have the licenses. And the next one would be property. So property is one of the main things that we look at in a company as well, because it will form part of their material assets. So in terms of property, we will look at all the properties that the company owns, and we'll also look at all the properties that they are currently occupying, meaning they may not own it, but they are actually renting these properties from other third parties. So all these properties that they own and occupy as part of their business operations, we'll need to scrutinize. We will need to scrutinize them a lot, because number one, there are a lot of compliance issues, which I will come to later, that needs a lot of time to resolve when it comes to properties. And in terms of properties, we also need to confirm, if the company tells me that, I own 10 properties, we will need to go through, for example, their land title, the relevant sale and purchase agreement to prove that, the company do own these properties. So we're basically not taking the company's word for it. We have to, as due diligence solicitors, we need to verify these statements by the company with source documents. Okay, the next thing that we'll look at is also employment. So this will come to the local and foreign employees that are hired by the company. Because when it comes to your employees, there are a lot of things that you may need to comply with, such as you have to at least pay the minimum wage. You would have to make sure that you do all your statutory contribution, like EPF, SOCSO, your EIS, or sometimes your HRDF contribution. And we have to make sure that they pay their monthly income tax deduction. So all these things about their employees, the company will also have to comply with. And sometimes we also look at their employment handbook and also some of their standard template employment contract to ensure that the employment terms that the company imposes on their employees are actually in compliance with the laws in Malaysia. So these are things we do look at. And if we do see certain, for example, they don't give you the minimum annual leave, then we will recommend the company to rectify it. Okay, so the next thing we'll look at is also financing. How the company, when the company takes up banking facilities for working capital purposes, for example. So a few important things to look at is actually whether or not the consent from all of these financiers will be required for them to even go for this IPO exercise. So the one of the most common consent required would be for the company for them to change their shareholders, because for all IPO exercises, for a company to even form the listing group to begin with, they will have to go through an internal restructuring, and where there will be certain changes in their shareholders. And for you to do that, there are certain covenants or terms in your banking facilities, where the bank says you need to obtain prior written consent from the bank before you can enter this kind of restructuring. So that's one of the more common consent. The other one would be if your directors of the company, or if your company, there are personal guarantees taken up by individuals outside the company or even directors of the company, we will need to write to the bank to request the bank to give the conditional consent to discharge these personal guarantees. Because at the end of the day, once you are listed, you do not want to rely on any external financial assistance from anyone, because you're showing the investors that your group is financially sound on their own. So therefore, we need, before submission, we need to write to the banks. We need to ask the bank to agree to discharge these personal guarantees to be replaced with a corporate guarantee by the listed company later on. So this is something that the company needs to do as well, quite early on in the IPO stage. And for litigation, it's quite important because litigation may come, it may result in a lot of contingent liabilities for the company. So we need to know how much, who are they suing, or who is suing them. So we need to look at all these ongoing litigation cases. We need to also look at any pending or threatened litigation cases. For example, if there is a notice, if there's a letter of demand sent, we also need to know, if there is an impending litigation coming soon. So all these we need to look through, and if it's something material enough, if it's a litigation case that involves, a very huge amount, and it may impact the financial condition of the company, then yes, we'll need to put it in the prospectus, and it's a matter of disclosure. We need to let the investors know, and also let the authorities know. So in terms of taxes, we also need to make sure that, the companies, they have been doing their tax returns on time. They have been paying all their taxes on time. There's no tax liabilities, no compounds by the tax authorities. This is just part and parcel of the company complying with the relevant laws and regulation. So I think the next chunk of it, I think Lily will take over.
Okay, yeah. So on the corporate information, I think this is something that is very easy. So basically, it's the statutory documents of the company. You just have to have the company secretary send to you all the relevant statutory filings and make sure that the documents are in place, and basically board resolutions have been passed, shareholders resolutions have been passed for all the major transactions that has ever been done by the company. This is quite tedious as well. There are times where, if the COSAC is unable to scan to you all the documents, you would then have to go back to the COSAC's office to do the physical inspection, as what Diane has mentioned. But in situations like this, I think what is important in relation to the corporate information is definitely the register of members, the register of directors, your annual returns, and also basically, when you conduct your CCM search itself, you just have to make sure that the business of the company is aligned with whatever they are currently doing. And in the event if there's a change of name, when was the company's name changed? In the event if the company was wound up or has been wound up, or even if it's dormant, you have to ask the company why and what happened, and whether such winding up or even was done because what are the reasons that such winding up was even done. In the event if it's those members voluntary resolutions, then obviously it's fine. But in the event if it's done by a creditor and all, I think it is necessary for us to probe further to understand why was it done the way it was. In relation to major customers, I think Diane has briefed you guys a bit on the contracts that we review. So in most circumstances, we will be looking at the 3 historical financial years of the company, 5 major customer each on each of the financial years. So at times some of the major customers may be different, sometimes it may be the same. In the event if it is the same and such customers have contributed tremendously to the business of the company, it is good to ask the company why and also consider whether or not the company is highly dependent on them. You wouldn't want the company to be highly dependent on them, because the question of whether in the event if this customer no longer comes back to you, in the event if this customer winds up, in the event if something happened with you and the customers, what would happen to your business then? Does that mean that financially your business will go all the way down because these customers no longer support you? In the event if that's the case, you do have to make such disclosure to the regulators in order for them to also understand why and whether or not there are any alternative to these customers. Or let's just say there are situations where you do not have major customers as well. So let's just say you are a property developer of condominiums. In circumstances like this, you definitely won't have any major customers, because your customers are individuals who probably buy 1 or 2 properties from you in the past financial years, and that wouldn't satisfy the threshold. So in situations like looking at major customers, you do have to look at their contracts. You do have to see whether or not there are any confidentiality clauses. You do have to see their length of relationship, documents to support that, in the event if the client tells you that they have been, making dealings for 5 years, you have to have documentary evidence to prove that in these 5 years, there were transactions being done. Of course, some of these information can be verified by the reporting accountant as well. So in relation to major suppliers, same thing as well. You would have to look at the same type of contracts. You have to look for confidentiality terms. In the event if you're highly dependent on them, what are the alternatives? Are there other suppliers out there, or do you really only rely on one and there's no one else outside? In major customers and suppliers, you also look at, sometimes they are foreigners. You might need to conduct bankruptcy and winding up searches on these companies as well. In the event if they are foreign entities, you probably need the assistance of foreign counsels to help you with that. But of course, there are situations where you can actually conduct searches, bankruptcy searches or winding up searches on these companies. So let's just say Singapore, I think Hong Kong or China as well. I think there are ways for you to do those searches. Moving on to intellectual property, I think what is really common here is the trademark of the company. So in situations where, I think if you have seen a prospectus before, the main page of the prospectus cover page itself, you would see the logo of the company. It is best to have that logo registered for the logo trademark, because in the event if some other company uses the same trademark, you do not want them to come off as like passing off of your company. And also it would be good if you protect, your client protects their own logos therein. There are situations where you look at the domain name of the company. You have to make sure that the IP address or the website of the company is registered with the company's with the company, and there are situations where you look at IP contracts as well. So in the event if there is an app agreement, or there's any other intellectual property agreement that's done with the developers, you have to check whether the rights belong to the developer or belong to the client. You have to check in the event if such information is breached, what will happen, and in the event if you no longer have that intellectual property, it would be detrimental to the business of the company or not. So these are some of the situations that you would have to look into. In relation to insurance, this is pretty easy. There are times where, there is a need for you to write to the insurance broker of the company to basically have them confirm certain things. Basically, the insurance is adequate and sufficient. There are no outstanding claims, and also there are no penalties or fine from any regulators or whatever in relation to the insurance that they have taken up. So you do want to make sure that the company do have sufficient insurance policy. And in the event, if it's a construction company, you have to make sure that they have those typical insurance that are taken up by those companies, like workman compensation and things like that. So you just have to make sure that the relevant policies that they have, they do obtain it. So in relation to non-compliances, we will talk a little bit more about that. But basically, you do have to look at documents of the company. You do have to probe and also look at documents of the company in relation to any non-compliances that has ever been conducted by the company. So I think even the tiniest bit you should actually find out. So there was this company, construction company as well, where they were breeding mosquito, and they have received a few fines from the authority. So I think if it's a one-time thing, it's fine. But if it's done 5-6 times in a year, you have to probe them as to why they were fined, they paid the fine, but why do they keep going on doing that instead of fixing the issue? So these are some of the things that the regulators might ask, because it wouldn't look like the company is trying to comply with the law in the event if they continuously breach the law in that way, even the smallest things. So on conflict of interest and related party transaction, it is quite important. It is a quite important disclosure to be made to the public and also the investors in relation to whether or not the directors, the shareholders of the company provides any business to our current group, and whether or not there are any related companies to the company that provides transactions that are ongoing or are recurrent, or is a one-time thing. So these are situations where the company will have to disclose to you as to who are the related parties, what are the transactions conducted, why it was conducted, and it is very necessary for you to ask the company for documentary support that the transaction that's being conducted is fair, it's at arm's length, and basically it is not detrimental to the company. Or even there are situations where you have to make sure that it is not unfavorable to the person providing the transaction as well. So it is best to make sure that let's just say if your related party rents a condominium or rents an office to the company, and it is at a very unfavorable term. Basically, the rental is 2 or 3 times higher than what is currently being offered in the same type of office in the same area. You do have to ask the company, why is it is the related party trying to profit off this company that's going for listing? And in event if it's too low, are you trying to manipulate the expenses of the company to make it look like you don't spend so much of money when you are renting out properties, but in the event after the listing you go back to renting a property that's of the higher price, it would look like your expenses have increased tremendously. You wouldn't want to do that as well. So documentary support for things like that is very necessary to verify that you have conducted your due diligence on these things. Yep. Then we can move on matters to resolve. Matters that are usually resolved. Yep.
Mike.
Yeah.
Okay, so on typical methods to resolve the examples that we set out are, you know, very common things that we face in an IPO due diligence exercise. And these things are also the things that are the ones that may potentially delay your whole submission. So remember, I think in an earlier slide, Lily mentioned that in an ideal situation where everything is, when the company is super compliant, there's no issues, it may take up to 10 months. But if you have these sort of roadblocks, then it may go beyond that. So I think the first one would be a certificate of compliance, completion and compliance, also known as CCC. So what this is actually more property related. So a lot of properties that companies have, sometimes they do not have this CCC. It is a certificate issued actually by an architect after you complete the construction of the building to show that, you know, this is safe for occupation. But for some reason, you know, in the course of buying properties, maybe when, for example, if a property changes hands so many times, the owner just does not pass on that copy of the CCC they have. And when it comes to the company that you're conducting due diligence on, the company then realize, you know, oh, I actually, you know, when I bought the property, I did not think to ask them for it. And now I don't know if they have it. So sometimes they either cannot locate it, or the bigger problem would be, you know, if the building actually does not have it. So when it comes to this, the company would then have to do one of two things. Firstly is to go back to the previous owner to, you know, try and request a copy from them. Or second thing, sometimes you can try, if you know who the developer of the property is, you know, you need to go back to the developer, if they're even still around, to try to request for a copy of the CCC. And if you are very sure that there is no CCC for the property, then it's a bigger issue, because now then you will have to start a fresh application for it. And this sort of process takes time. And this is the process that will be the one that delays the whole IPO. So always ensure that the property has the basic documents, most important one being the CCC. The next one would be fire certificates. So in terms of fire certificates, under the law in Malaysia, not all property will require a fire certificate. Only if your property is of a certain size and of a certain usage, then if you fall within those criteria, they call it the designated premises in Malaysia. So if your property falls within those criteria, then you need a fire certificate. But I think this is something that a lot of companies in Malaysia, they typically overlook, because I think it's something not highly enforced in Malaysia as well. But in terms of IPO, because we have to scrutinize all sorts of compliance by the company, this is where we will highlight, you know, certain properties of them where we realize, you know, it's big enough, and depending on the usage of it, we will be of a view that, you know, a fire certificate is required. Then the company will have to go to their fire consultant and, you know, start this whole fire certificate application process. And again, this takes time. It may take up to months, because you have to prepare, you have to draw up a plan, you have to go to Womba to get their approval of the plan, then you have to install your fire system and all that. So it all takes a lot of time. That's why in terms of the first and second bullet point, it is something where we need to flag up very early on in the whole IPO process. So if things get resolved earlier on, then we mitigate any delay. The third one would be illegal extension. So I think this is also a very common thing we see, where the company, maybe they renovate their property without getting the necessary approval from the council on their, you know, amended building plans and all. So again, when we realize that, you know, even if you add a zinc roof or just an additional shed and all that, all of these actually will require your local council's approval. And it is something that a lot of companies, once again, they do it out of convenience. You know, if you don't go for IPO, it may be just something that you renovate out of convenience. You know, you have extra space. But when you go for IPO, all these you will need the approval of the local authority. So when we find these problems, we will need to then go back to the company and say, you know, hey, you gotta put in the necessary applications, get the necessary approvals for all these extensions. Either you demolish the extensions or you get the approval for it. Either way, it would take time. Okay, the next one would be on the certificate for accommodation. This is so in terms of certificate for accommodation, it is actually when you have foreign workers and in Malaysia, employers are required to provide accommodation for all their foreign workers. But in terms of the how the accommodation is like, there are minimum standards for employers to comply with. And I think in September 2020, during the pandemic era, there was this new requirement that came into force to say that all workers' accommodation in Malaysia must be certified with a certificate for accommodation. So this is where all the employers are supposed to, if you do provide workers' accommodation, you're supposed to make an application to the Department of Labour of Malaysia, and then you have to get them to come and inspect your accommodation. And if your accommodation it complies with all their minimum standards, then they will issue you with this certificate. So because it is a rather new, I would say it's a rather new recent requirement, and it is also currently being enforced now by the Department of Labour. A lot of our clients, they take some time to actually apply and obtain this certificate for accommodation. And it's something that also requires time, because I think because it's a rather new requirement, there are a lot of similar applications put in by a lot of employers throughout Malaysia. So that sort of puts in a backlog in terms of application. So when we know that there's this problem, we will want the company to put in an application as soon as possible. But then again, this is also something that is recurring in a lot of different files, because I think it's a new requirement. And the last one is licenses and its conditions. So depending on what the company does, so the example that I gave earlier, if, for example, if you have a manufacturing license, there are some manufacturing licenses that have, equity condition. For example, a condition for you to comply with is that you must have at least 50% local employees. And for certain industries, for some of our clients who are in very labor-intensive industry, it is actually practically very hard for them to comply with this condition, because number one, if it's labor-intensive, it is not attractive to local employees. So it is actually easier for them to get foreign employees to come work under those circumstances, because it's just not attractive to the locals. So that is where you may meet one of the roadblocks, because to go for IPO, you need to show the regulators that you have complied with this condition. So when you note that you can't comply, there are also one of two things that you need to do. So the first thing is either you do all things necessary to comply with it. So for the example that I gave earlier, then you will have to go actively search for your local employees to meet that 50% threshold. So if that is not feasible, then you will need to write to the relevant authority that issued the license. So for manufacturing license, it would be MITI and MIDA. So you have to write to them, the relevant department, to ask for an extension of time for you to comply with this condition. Either that, or you have to ask for a waiver of this condition. So when you write to authorities, there is no, you can't say for sure when you will get a response. And that is why when it comes to compliance of these license conditions, it is very crucial, because it may take time to resolve as well. And from the regulator's point of view, they want all of these issues solved upon submission of your IPO application, regardless of how hard it may be to resolve, or how impractical, or how much cost you may need to incur just to resolve these issues. If you want to go for IPO, the reality is you just have to resolve it. So that is the typical issues that we meet and roadblocks that we meet in the IPO files that we've been doing. Lily, you have anything to add on this?
Yeah, no.
Okay.
Okay. Yeah, so now we move on to the expectation of what corporate lawyer, or in our case, a capital markets lawyer, would be like. So I think I have mentioned just now that there is a lot of partying, and there is a lot of situations where we are invited to client event and things like that. So these are some of the pictures that we have gotten from our past. Basically, these are our clients, and also some of them are the investment bankers as well. But I think the reality of our hard work is that these are behind the scenes on things that you probably don't see, and it's not shown anywhere in RDS's social media. Is where we go for a lot of site visits, and usually these places have no air conditioning. It's smelly, it's hot. everyone's sweaty, but you still have to dress formally because, you know, we are in a professional industry, and basically even though it's hot and everyone around you is sweating like mad, you just have to show that you are professional. So these are some of the situations where you know, we I think recently we went to a junkyard, and basically we have to put on, you know, uniforms, you know, to basically comply with the law, and yeah, it's just not as fantastic as what everybody sees lah, essentially. Yep, so that was a rubber factory. That was a rubber factory where we went as well. You know, the place was big. There were, you know, a lot of workers. But one thing that they didn't forewarn us before that was that there is a really pungent smell. If anyone would have known how rubber is made out of, you would understand that there is a lot of ammonia. I think ammonia is the term. I'm not 100% sure. I didn't really take on chemistry in in college, but yes, it smells really bad, and the smell actually stick on you for, you know, a period of a week or two, and basically I will never forget that experience. I think it is a good exposure for a lot of people, but at the same time, it's real hard work. Yeah. And then we move on to our slide. This is where hold on, then don't click first. This is where, you know, this is our team members. Our team is actually bigger than this, but essentially these are some of our core members. I think we have some of them in this call as well. Thank you so much for joining us, Vincent, Rowena, and all these other colleagues of ours that are too free. And we also have some of our past, you know, team members who are in this call as well. I think Kenny and Shirley as well. Thank you so much for joining this call. And last but not least, obviously we have our boss, Eugene, to thank for. He is always really, you know, encouraging and always motivating. He has goals for us, and, you know, we hope that we make him proud. He is a really pragmatic and also commercially sound lawyer, and he is a good boss to all of us. So that's why we have a picture here specifically to thank him for it. Yeah. Okay, so we have already gone through all our slides, and now it's the Q&A session. I think there are two questions here. The first one is from Jennifer, who is asking what is material contract and how do you determine material contracts? So, okay, just to, you know, sort of provide you with some clarity, usually materiality will be determined by the due diligence working group. So this is where the advisors on the kickoff meeting itself, they come together to understand what is the current profit after tax of the company or the net asset of the company. And usually the materiality will be 5% of any of these two categories. And you would then have to determine whether quantitatively the contract falls within the threshold or not. And also qualitatively, you are looking at whether it is whether it is in the ordinary course of business, whether this contract was done in the ordinary course of business. So if yes, then in most situations, it is not a material contract. You also have to see whether or not it's onerous, whether or not basically it's one-sided, whether you're dependent on it, as mentioned just now. And in situations like this, you do have to flag up to the advisors on these contracts in order for them to be disclosed in the prospectus. So I hope I answered your question. So I think we have this next question as to, could you go back to the first slide? Would like to take a look again. Which is the first slide? How do you?
Okay, I think while we go back to the first slide for waiting, we'll just answer Hui Ying's question briefly on the ESG and sustainability in the IPO process. So I think in recent times, and I think also because of the COVID-19 influence, I think ESG has been one of the things that the regulators do ask for companies. I mean, ESG so far has not been part of the legal due diligence process side, but I think the internal control consultant, which is a different advisor in the due diligence working group, they will have to start looking into the ESG and how the companies are actually integrating this ESG into their company's business operations. So it is something that the regulators are looking at as a whole. It's not something we look at it from the legal point of view, but yes, in terms of ESG, it is quite important as part of the whole company's operations. So I hope that answers your question, Hui Ying. Are you talking about this first slide? Okay, so there's one question.
Okay, so what can students do to build their interest in this area? I think this is a very good question. You can do that by doing a stint with us as an intern or a paralegal, come in for at least 3 to 6 months just to understand what is it that we do and how is it that you can sort of expand your interest or determine whether or not this is something for you. So the best answer to that question is come and be a paralegal for us. Yeah, so I think this is the cake and the cream slide. I'm not really sure what's the question here, but this is essentially our thought, our love for IPOs. To us, IPOs are the cherry on top of the cake.
Yeah. Okay, I think there are no further questions from the audience.
Yeah.
I think with that, we can end today's session. Thank you all for taking up 1 hour of your time to be with us, to see what we have to share. I think there's anything for you to add, Lily?
No, I do not have anything. I think there is a question here where they ask, in the event of a failed IPO, will there be any process to take down their submission? I think, if I'm not mistaken, the prospectus exposure will be removed from the website. In relation to taking down, it will not be seen by the public. Yeah.
I think there's another question by Jennifer, how to apply as an intern under your corporate team. Okay, so I think our emails are around. If it's not in the website, it is lily@rdslawpartners.com and Diane is Diane@rdslawpartners. Yes, do apply to us. We are open to taking interns and also okay, just to clarify, I think right now for our firm, it is essentially called interns. Everyone is treated the same. You are getting paid the same amount. We are open to look for paralegals who are currently known as interns. Yeah, so do apply to us. Yep. Anything else? Thanks, Gladys. Okay, yeah, so I think that's the end of it. Thank you so much for taking your time, and we hope to hear from you guys soon. Goodbye. Bye.